I'm Mike Hackard. Blended families are part of modern life, but when it comes to inheritance, they can also be the source of some of the most painful and complicated disputes. One of the most common situations we see estate disputes involving stepmothers. They're not just about money, they're about emotions, family identity, and unresolved history. Today, I'll walk you through why these disputes happen, why they're so charged, and how families can work toward resolution. Why step relationships trigger estate conflict. Imagine this: a father remarries later in life. He has children from a first marriage. When he passes, his estate plan leaves the majority of assets to his second wife, the children's stepmother. For the children, this can feel like betrayal. They may ask, did dad really want this? Was he pressured? Was he even capable of making that decision? For the stepmother, it feels like she's being unfairly attacked. After years of caregiving and companionship, she believes she's simply honoring her late husband's wishes. This is the heart of many disputes, two perspectives, each grounded in a very real emotions. Common allegations. Three accusations come up repeatedly in these cases. Undue influence. Children may argue the stepmother used her position of trust to pressure their father into changing his will or trust. Unequal distributions. If the bulk of the estate goes to the stepmother, adult children may feel cut out or blindsided. Questionable documents. Wills or trusts that appear late in life or that replace long-standing plans often lead to claims of invalidity. Add in unresolved family wounds, feelings of neglect, jealousy, or favoritism, and the legal dispute becomes an emotional firestorm. Why the law isn't enough. You might think if dad had a clear will, there wouldn't be a problem. In reality, even the best drafted documents don't erase emotional pain. Estate disputes with stepmothers are about law and emotions. One without the other rarely solves the conflict. This is why cases drag on for years, not because of legal complexity alone, but because of hurt feelings that go back decades. Mediation. A path forward. Court battles are sometimes necessary, but they're expensive, slow, and often destructive. Mediation offers another way. In mediation, each side has a chance to share not only legal claims, but emotional perspectives. A stepmother might explain the sacrifices she made caring for her husband. Children might describe how they felt excluded from his final decisions. With a skilled mediator, families can often reach compromises. Maybe the stepmother keeps the primary home, while the children receive other assets or a structured fund. It's not perfect, but it often saves time, money, and relationships. Practical steps for families. If you're facing one of these disputes, here are 5 steps to consider. Start with communication. Calm, respectful conversations can sometimes resolve misunderstandings before they escalate. Consult legal counsel early. State laws for blended families are complex. Get clear on your rights before taking action. Consider mediation first. It's faster and less adversarial than litigation. Document everything. Keep copies of wills, trusts, financial records, and correspondence. Protect your well-being. These disputes are draining. Rely on personal support networks and professional guidance. Closing estate disputes with stepmothers are tough. They mix law with love, inheritance with identity, and they don't just risk assets, they risk tearing families apart. At Hackard Law, we've helped families through these difficult conflicts with both legal skill and human understanding. If you're facing an estate dispute in a blended family, don't go it alone. Get experienced guidance, protect your rights, and protect your family from years of unnecessary conflict. I'm Mike Hackard. Thanks for watching. Schedule a consultation at hackardlaw.com or call 916 313 3030.